job losses, but also to health and safety issues, and also linked with organized crime, which is pretty much established by all law enforcement agencies. I'm referring, of course, to counterfeiting here. Our 2008 customs seizures indicate a whopping 178 million articles counterfeit seized. And if you look into details, you see a number of very dangerous counterfeits which are increasing. Cosmetics, 5 million, toys, 5 million, electrical appliances, etc., etc. The OECD, which to my knowledge is the only widely recognized international study on the matter, has valued the counterfeit business to $250 billion per year. And that is only physical counterfeit, which is internationally traded. So that excludes domestic consumption, that excludes non-tangible goods. There's been just last week a study, we don't know the details of this study, but the study of MASCAP mentions that for piracy, a large amount of EU jobs, 1.2 million, lost in 2015. I put a question mark. This is not a European Commission study. It's not an official organization study, but still, it is a number. So now I hear, and we've been told that this should be then addressed in the appropriate organizations which are dealing with intellectual property, whether it is a World Intellectual Property Organization in Geneva or WTO or the World Customs Organization. Problem is, let's put it clearly, it is extremely difficult, and all these organizations do a very important work in fighting counterfeiting piracy, which we support, but it is extremely difficult because of the consensus, because certain countries do not want the word enforcement to be mentioned in these negotiations. This is the reality, so this is not with no surprise that a number of countries who are willing to go ahead have decided to join together. Whom ACTA, I think is very well known, but just for clarity, 11 parties in 5 continents. So it's a pretty wide coverage, including with developing countries. Of course, the idea is not to have a closed club or to leave the membership as it is. The idea is very much that the agreement should be open to other governments or other countries to join later on, and we are making sure that this will happen. ACTA, what is it? What is the content of ACTA? Well, first of all, the guiding principles as far as the European Union is concerned. First guiding principle is that there will be no change in European legislation. There will be no either harmonization or change of substantive law for intellectual property. So this means that, for instance, and I've picked up the most spread, or the most widely spread rumors, because they are rumors, which I've read, that there's going to be a 3-strike rule or a graduated response mechanism. This is simply not true. No ACTA party has ever proposed it, and even if one party were to propose it, we would refuse it for the reason above, that it would go beyond what is harmonized in Europe. Similarly, I've also heard things that, rumors that say that we're going to change the ISP liability or their role, or that we will impose filtering on the Internet, etc. This is absolutely not true. Equally, there will be no attempt to the legislation on privacy data protection which we have in Europe. I've seen that the European Protection EPDS has made an opinion on this. We have no problem respecting all that. We have absolutely no intention to do this. And finally, the last most spread rumor concerns what could happen to individual travelers. And here, clearly, we are not introducing new provisions on alleged custom searches for, I don't know, individual laptops, MP3, etc. I think that customs officers have other things to do. Second guiding principle is that ACTA is an enforcement treaty. It's not a substantive treaty. So it will not change the checks and balance, if you want, of rights or the obligations or the exceptions, etc. It's exclusively about enforcement of existing laws. So we're not changing, I don't know, duration of copyright or this or that. This is exclusively about enforcement. And last but not least, criminal sanctions, which, by the way, are not negotiated by the Commission by the rotating presidency, because it's a non-harmonized matter, will only deal with infringement on commercial scale. So there will be no criminalization of the proverbial innocent housewife, as I've sometimes read as well. Now, the rest of what I'll say will be the consequence of these three guiding principles. There will be 6 chapters in ACTA. The most important one on which I will dwell a bit will be regarding the legal framework for enforcement of IPRs. There's also international cooperation where we are working with similar countries to make sure that the agencies work well together so that we also avoid duplicating technical assistance activities, etc., and that we can also develop capacity building, which is very important. If we go in details now on the chapter of the legal framework, which is itself composed of 4 sections, and for the European Commission, clearly, as I've said, the position of negotiation is based on the acquis, so on the directives that you are seeing here. Clearly, we will not move from this law, from this legislation. And this is, of course, concerning what the EU position is. And, of course, I have no intention to speak of the other parties' position that is for themselves to organize similar transparency events. Is ACTA secret? Well, first of all, ACTA, I think, is one of the few international negotiations which was announced before its launching in this very room in the first stakeholders consultation meeting which we had in 2008. This being said, I should add that, as far as I know, I do not know any international negotiations which are public. If you go in WTO or WIPO, you don't have cameras inside the Director's General room when he's negotiating with ambassadors or ministers. This being said, the parties in ACTA have agreed on confidentiality rules, which, of course, intend to respect. But we have informed duly the European Parliament as of 2008 in the INTA committee and yourselves in 2008 and 2009. We can, of course, only inform of what is existing at this stage. We cannot inform in advance of what has not been discussed or what has not been agreed or what has not been touched yet as a chapter, which is the case for 1 or 2 chapters. This being said, we understand that there are a lot of concerns and that sometimes ignorance feeds rumors, and sometimes rumors are also fed by groups with a different purpose. And so clearly, because we have nothing to hide, we EU, as I've just explained, on what was guiding our position of negotiation, which is our legislation, which by definition, of course, is public, and you all know well, we will definitely request from our partners the possibility to release the negotiating text and try to obtain a consensus on this matter at the next round in New Zealand in April, and so that everybody can see that we do what we say, and actually we say what we do as well. State of play and next steps. We started in June 2008. There were 7 rounds so far. The next round will be held in a few weeks in New Zealand with a goal of concluding in 2010. There will also be a civil society meeting organized by the host, the New Zealand government, during the next round in Wellington. All the chapters will be on the agenda this time, and clearly, as I've mentioned, a cross-cutting issue like transparency will also be on the agenda. We've solidly insisted on this. So, thank you very much. This is now your turn. I would like to also draw your attention that there's a lot of material which we have published on our website as well. There is a summary of each round of negotiations. We also hope to obtain very soon the agreement of all our partners to publish an updated fact sheet so that it is clear that many of the principles which I've highlighted will be also confirmed by the negotiating partners. And as I've said, we have nothing to hide. So this is your time now. Thank you very much. Yes.
Hello, I'm Jeremy Zimmerman from citizen advocacy group La Quadrature du Net. Actually, I've got a few questions for you. The first one in the form of a troll, as we say on the internet, is you say